Clarence Thomas has spoken, literally. Quite famously, it's been about a decade since Supreme Court Justice Clarence Thomas spoke during oral arguments in the Supreme Court, and yesterday, suddenly, he spoke. Now, what topic was seemingly so important that it caused Clarence Thomas to break his 10-year vow of de facto silence? None other than guns. He asked many questions and completely changed the direction of the oral arguments in Voisin v. U.S., which is a case involving domestic violence and gun rights. The Supreme Court is currently considering a case which would make it easier for people convicted of misdemeanor domestic violence offenses to keep their gun rights. As you may know, although you may not, since 1996, if you're convicted of a misdemeanor domestic violence offense, you are banned for life from possessing a gun. Clarence Thomas stepped in and raised a broader constitutional question, which, as some are suggesting, maybe would have been raised by the late Antonin Scalia. Here's a quote from Mother Jones about how it went down. The oral arguments in the case appeared to be wrapping up early. Ilana Eisenstein, the Assistant Solicitor General, said to the justices, if there are no further questions, long before her time had run out. Then Clarence Thomas shocked the courtroom by asking her whether she could think of any other example where a misdemeanor criminal conviction could deprive an American citizen of a constitutional right for a lifetime, in this case, the right to own a firearm, which at least as of now is still a constitutional right. This continues to be explained in Mother Jones by going on and saying Thomas continued to press her, asking whether a misdemeanor conviction could deprive other people of other constitutional rights, perhaps under the First Amendment. Let's say that a publisher is reckless in the use of children and what could be considered indecent displays, he posited in a deep, booming voice rarely heard in the chamber. Let's say it's a misdemeanor. Could you suspend that publisher's right to ever publish again? Now, Lewis, it's so crazy that Clarence Thomas spoke during oral arguments that reporters started running into the courtroom. I mean, imagine the scene, 10 years without speaking, to the point where when you merely ask a couple of questions, the courtroom is all of a sudden filled with reporters.
It's shocking. Yeah, it's also quite interesting, as you pointed out, that as soon as there's no Scalia,
right,
Thomas talks. And I don't know what the dynamic was like in there. I don't really know much about that.
Right.
All I know is he's been silent.
And this actually has been sort of discussed by Clarence Thomas. He says from when he was a little kid, he always preferred to listen. And he says this dates back to when he was in school. He had a particular accent which made his speech difficult for others to understand, and he sort of took to listening instead of talking. And of course, a number of followers of the Supreme Court are saying, you know, there's this idea that Antonin Scalia's presence was the sort of more comfortable public speaking voice of Clarence Thomas, and maybe he didn't feel as much of a need to speak when Antonin Scalia was there. Very shortly after the passing of Antonin Scalia, Clarence Thomas is all of a sudden commenting, and it is very, very interesting, and we'll continue to follow it. But this is something that legal scholars have talked about for a very long time, a decade vow of silence in practice.
Yeah, and it's a strange practice. I feel that he should be part of discourse, but I guess it's his constitutional right to remain silent.
Well, the counter is he is a judge, and he can express his opinions in written form as part of the decision, and that's that. Of course, every once in a while, maybe people want to hear from the guy and see what he's thinking as these oral arguments are going on. Very, very interesting and just generally unusual situation.